I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on state open meeting laws. As a reminder, all of our classes build off one another. So if you haven't already, please view our previous lessons on open meetings and executive sessions. They'll give you a good overview of the law and lead into what we'll be discussing today. We also have a growing library of lessons on state public record laws and the Federal Freedom of Information Act. All these lessons can be found on our YouTube channel, as well as in our FOI guide at nefac.org/FOI guide. Before we begin this lesson, a special thanks to those helping us make these classes happen: the Society of Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on state open meeting laws. This session is going to focus on citizen participation in government meetings in New Hampshire. And with us is Greg Sullivan. He's president of NEFAC and the general counsel for the Union Leader Corporation. And he's going to explain to us about making public comments during open meetings and give us some tips and advice for citizens who would like to make their voices heard at those meetings. Greg, thanks so much for doing this. I appreciate it.
Thank you, Emily. My pleasure. Good evening, everybody, and thanks for joining in. I hope you all can see the first slide that I have to show you this evening. And I'm not sure you can read everything on that slide. Matter of fact, you can probably only read 4 words. And because we're not in a classroom, I usually quiz the class as to whether they can see those 4 words. And I say that the framers made those 4 words bigger than all the other words because they're the only 4 that really matter, at least for our purposes this evening. So those 4 words are "we the people" up the top, and then at the bottom, "done." And I say that "we the people" done is all you need to know, because we are the government. We own the government. We own the White House. We own the State House. We own the City Hall. And as we'll see in the Constitution of New Hampshire, that becomes abundantly clear. So I teach a class at Suffolk University Law School in Boston, as well as other spots. And I call it defamation, privacy, right to know. Below that, we see the First Amendment. It's 45 words. And sometimes I call my class the 5 freedoms. Those freedoms, of course, religion, speech, press, assembly, and petition, are guaranteed to all U.S. citizens. And when it was written, it was "Congress shall make no law." But in 1925, the Supreme Court made it clear that it's every governmental agency and actor, federal, state, and local, that are bound by the dictates of the First Amendment. So what we're going to talk about this evening a little bit is our right to know what our government is up to. Here in New Hampshire, we have a constitution with some great provisions, not the least of which is Part 1, Article 22, which says that free speech and liberty of the press are essential to the security of freedom, and they ought therefore to be inviolably preserved. It's stronger language than even the First Amendment. Part 1, Article 8 tells all government agents and offices that they are our substitutes and agents, and they must be accountable to the public. Government must be open, accessible, accountable, and responsive. To that end, the public's right of access to governmental proceedings and records shall not be unreasonably restricted. I'd like to say shall never be restricted, but that word "reasonable" does underlie all law, and we'll see instances where it is reasonable for the government to limit speech and press rights. However, the Supreme Court of the United States made it very clear in 1989. This fellow, Mr. Johnson, had burnt an American flag outside the Republican National Convention in Dallas in 1984. He was convicted of both state and federal crimes for burning the American flag. 1989, the Supreme Court said, hey, we've got a bedrock principle that says the government cannot shut people up just because the government or society, the majority of society even, finds the idea offensive or disagreeable. We're going to talk about that bedrock principle later when we see ordinances passed by local governments in New Hampshire. So the train on the left represents our 5 freedoms guaranteed by the First Amendment. That train on the right represents other governmental or societal interests that will sometimes crash and clash head-on with our rights. But in New Hampshire, the purpose of Chapter 91A, our right to know law, is to ensure the greatest possible public access to actions, discussions, and records of all public bodies and their accountability to the people. I will say, however, that our right to know law does not cover the legislature, the governor, unless the governor's meeting with the governor's counsel, or the courts. And to get the records and access to those groups, we rely on Part 1, Article 8 of the New Hampshire Constitution. This is the preamble to the right to know law. And as you can see, openness, the framers of this statute said, is essential to a democracy. And again, we want to ensure the greatest possible public access to the actions, discussions, and records of all public bodies. So what are these public bodies we're talking about in New Hampshire? And this is all by statute 91A, the right to know law. So any board of any state agency, including UNH, advisory committees or otherwise, a legislative body, a governing body, a board, commission, committee, agency, or authority of any county, town, municipal corporation, school district, school unit, public school, or political subdivision, committees, subcommittees, subordinate bodies thereof, advisory committees as well. Any corporation that has as its sole member the state of New Hampshire. And then, of course, any county, town, municipal, again, all those subdivisions of the state government. What is a meeting? If we want the right to attend public meetings, we need to know what a meeting is and what a meeting is not. So for purposes of 91A, it's the convening of a quorum of the membership. And sometimes quorums are defined as less than or more than a majority. So it's a quorum or a majority if that public body defines quorum as more than a majority. All you need is a majority of the people to be meeting, and that is a meeting. And that's whether they're meeting by telephone, Zoom, etc., as long as all the members can communicate with each other contemporaneously, then there's a meeting. And it has to be held for the purpose of discussing or acting upon any matter over which that body has supervision, control, jurisdiction, or power. And we all know after the completion of the meeting, they have got to create minutes. In addition to the minutes, we have the right to inspect notes, materials, tapes, any sources used for compiling the minutes, and to make memorandum, copy them. And of course, what we all do now with our smartphones is take a picture of them. That's the least expensive way to get the records, of course. So they have to keep these records at their regular office or place of business. If there is no such place, which doesn't make much sense to me, those public records shall be kept in an office of one of their subdivisions or at the office designated by the Secretary of State. But they have to keep these records for public inspection. This is a bill that came out of committee recently with a 20-0 vote. It hasn't been voted upon by the legislature. And a lot of people think it has to do only with public records, but it also has to do with public meetings. And it says if a city, town, board violates 91A, and a lawsuit is brought in order to enforce compliance with the law, that requester will be awarded attorney's fees so long as they prevail in court. As it says, the court renders a final judgment in favor of the requester. Right now, it's the requester has to show that the public body knew or should have known what the law was, that either the records or the access should have been granted in order for the requester to get attorney's fees. This new law will take that component out, the knew or should have known, and it's if you prevail, you get attorney's fees. So we're hopeful that will pass. But it works both ways. Court can award attorney's fees to the public body or agency or even an employee if they have to defend against the lawsuit and the court finds that that lawsuit was brought in bad faith or was frivolous, unjust, vexatious, wanton, or oppressive. Important to note that it's not just these attorney's fees and the awarding of access to the records or meetings, but that the courts can invalidate any action taken by these bodies if they were done in violation of the law. Additionally, they can issue an injunction stopping future violations of the law. So under public records that the statutes give us access to, it's minutes of all public proceedings, and the minutes have to have names of the members of the body, names of people appearing, what was discussed, and any final decisions. And if we are at the meeting, we can later compare what the minutes say with what actually was said, and perhaps we even recorded the meeting to make sure the minutes are done accurately. Same with non-public meetings. They've got to keep those same minutes, and we have the right to them 72 hours after the meeting, unless the board votes again to keep them sealed, and they've got to justify their reason for doing that. Well, this slide's a little earlier than I hoped it would be, but particularly when dealing with public records, if you ask for them and the agency says, no, there's private information in there, you say, hey, redaction, take out the private stuff, give me the rest. I like to call it red action. So again, a meeting is a convening of a quorum of a membership of the body. But a chance social or other encounter not convened for the purpose of discussing or acting upon matters shall not constitute a meeting if no decisions are made regarding such matters. So that tells me if a quorum of the Board of Selectmen attend a wedding together, they can discuss public issues, but certainly cannot make any decisions. Sometimes I think they do that with a wink and a nod. What else is not a meeting? These agencies have the right to go into executive session, and these are common sense things, to discuss negotiations with a collective bargaining unit, consultation with their attorney, and partisan political party meetings. All of those are not meetings that we have a right to get into. Not a meeting is the circulation of draft documents, although when they're finalized, they're going to formalize a decision. But those draft documents and the circulation of those do not constitute a meeting. So here we get to the meat of the issue. Subject to other sections of the statute, all meetings, whether in person or electronic, shall be open to the public. And then it tells us that all votes have to be taken in public except for town meetings, school district meetings, and election. Those votes can be taken by secret ballot, and at these meetings, we can use recording devices, tape recorders, cameras, videotape, etc. at these meetings. Again, the minutes, and again, we like to compare the minutes with what we know happened at a meeting, have to be included in the minutes, including a description of what was discussed and, of course, any final decisions. Names of the people who made and seconded the motions. 5 business days after requests, we have to get them, and they are treated as permanent records of that body. We have to have 24-hour notice on any meeting that's not an emergency, and it has to be posted in 2 places, appropriate places, usually the city or town hall, or one of the places can be an internet website. This is from the website of the Governor's Council in New Hampshire. And it says all their meetings are open to the public. It's an opportunity for the public to comment on the nominees before the Governor's Council for government positions, including judges. But they make a good point, I think. Public comment can be submitted by email. To me, putting things in writing to be clear what your position is always a good idea. Even if you bring it with you and you speak at the meeting, submit your comments in writing is, I think, a good thing to do. So what can we say? What can't we say? This is an ordinance recently passed by the city of Nashua. And the public comment allowed an A and B above, and A and B tells us when the public comments will occur, but they say excessive repetition and irrelevant remarks are discouraged, okay? But then they say crude, vulgar, profane, and or obscene remarks are prohibited. Presiding officer has authority to terminate the remarks of any speaker when such remarks do not adhere to this ordinance or other applicable law. And I have a problem from a constitutional point of view with this particular ordinance. As I say, I think it was passed just at the end of 2022. Because if we go back to the bedrock principle underlying the First Amendment, it says the government cannot shut us up just because they don't like what we're saying. And these definitions, my definitions of what's crude, vulgar, profane, and even obscene may very well differ from everyone else's understanding in the world. So I consider this ordinance to be vague and overly broad. I think we have the right to be crude. I think we even have a right to be vulgar. I know there was some language I listening to the House of Representatives in Washington the other day, and I forget some movie actress or entertainer who was calling somebody a pussy bitch, and that's in front of Congress. Now, I think the mayor and board of aldermen in Nashua may very well think language like that is crude, vulgar, profane. I don't know what profane means anymore. When I was a kid, we were taught that it was profane to take the name of the Lord in vain. Whenever I think of profane, I think of anti-fane, trying to distinguish the two. Crude and vulgar, I don't know what they mean. What I might think is crude and vulgar, someone in Las Vegas might think is ordinary language. So I suspect that ordinance may very well be successfully challenged at some point. Not sure what obscene remarks are. And by the way, well, let's see, I have some definitions I tried to come up with. Coarse or explicit, especially in relation to sexual matters. That's crude. Coarse or explicit, crude. I have trouble understanding that. Vulgar, lacking sophistication or good taste. Unrefined. I mean, I try to refine my language, but I don't know how sophisticated or how good my taste is compared to the people sitting on the board in front of me. Oh, I found profane in the dictionary. This is all Merriam-Webster dictionary definitions. Profane is grossly offensive language, not just offensive language, but grossly offensive language that is considered a public nuisance. I don't know. I may have to go up to a meeting in Nashua someday and See what I can get away with under the ordinance. And obscene, if it doesn't have to do with sex, it's not obscene. So I don't know how that fits into that ordinance, but the Supreme Court said in the case of Miller v. California many years ago, in order to be obscene, something must appeal to the prurient interest. I looked up that word prurient, and it takes you to salacious, and then I looked up salacious, and it took me another word. I went around in a big circle, and I have no idea what that means. Depicting or describing sexual conduct in a patently offensive way, not just an offensive way, patently offensive. And of course, if it passes the SLAPS test, it's not obscene. And the SLAPS test tells us that if the language taken as a whole has serious literary, artistic, political, or scientific value, it's not obscene. We call that the SLAPS test. Serious literary, APS, SLAPS. This is a New Hampshire statute, and I've pulled it up because people have been removed from various governmental proceedings and charged with disorderly conduct. So what is disorderly conduct under the statute? It's purposefully causing a breach of the peace, public inconvenience. That's interesting. Annoyance or alarm. That's an interesting statute that could be challenged as well, because I think we can make things inconvenient, and we certainly have the right to annoy. I'm sure I'm annoying a lot of people as I speak this evening. Or alarm recklessly creates a risk thereof by disrupting the orderly conduct of business in any public or governmental facility. So that's what they're going to rely on if they're going to drag you out of a Board of Aldermanic meeting for saying things that they don't want you to say, or as happened to the poor fellow in Vermont the other day, he was limited by ordinance to speaking for 3 minutes at the public meeting, and he spoke for 4 minutes. And in fairness to the board, they asked him repeatedly to stop, and he refused to stop. So he was arrested and charged with disorderly conduct. Usually those cases are ultimately dropped upon the payment of court costs, I must say, unless, of course, it's your third or fourth offense. So B and C of that 644-2 say disrupting any lawful assembly or meeting of persons without lawful authority. So both of those could apply to conduct in a public meeting. And again, I go back to Texas v. Johnson. When I look at particularly that Nashua ordinance, it's like, wait a minute. Government cannot shut us up, cannot prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Many boards do not allow members of the public to comment during the regular part of the agenda. The board's bylaws should spell out what is allowable for audience participation at board meetings. So my tip to you is, if you're going to go to a particular governmental meeting, find out if they have bylaws or rules, and find out what they are in advance, so you don't find yourself in hot water for merely trying to convey the ideas you think are important. And this is a tip for boards. Instead of having 20 people who want to speak during the 15 minutes that's been set aside for public comment, and whether it's limited to 2, 3, or 5 minutes, and all of those are contained in various local ordinances. There, by the way, I must say, there is nothing, I don't believe, in state law in New Hampshire guaranteeing us the right to speak at any kind of a public meeting. Albeit, if they have rules that do allow for public comment, and this is why I say find out what the rules are in advance. If they do have the rules and you are not allowed to follow the rules and convey your opinion, that's a different issue. But what this tip suggests is that if it's something that's, both sides are going to be vocal on, and certainly we've had many of these hot topic issues in not only recent years, but in recent days and weeks, whether it's, transgender children in school or vaccinations or masks, whatever the case may be, the boards are doing the right thing by scheduling a separately designed listening session for both sides of the issue to air their views. This is Manchester, the largest city in New Hampshire. This is their rule for public comment. They will be conducted at each monthly regular meeting. This allows residents to address items of concern. The session shall be a period of time not to exceed 30 minutes, during which any member of the public may have 2 minutes to address any single topic. And I'm often wondered about if I'm the only person that is going to speak and they've allotted 30 minutes or 15, whatever the case may be. If I'm the only one that's going to speak and they've allotted 30 minutes, am I going to be held to my 2 minutes? Or might they give me another minute? And then you'll see at the bottom, it's the mayor who picks the members of the public who can get 3 minutes to speak. However, again, looking at the rules in advance, if you want to speak at a meeting of the mayor and the alderman, you've got to sign up in advance. And if you are given 2 minutes and you only need 1 minute, you can't give that other minute to your neighbor who may or may not speak on behalf of your ideas. The mayor reserves the right to select speakers of different issues to be permitted to speak in order to provide a forum of various topics to be presented. Obviously, we're putting a lot of trust in the mayor. This is one I bumped into while researching these issues on the internet from Illinois. No person shall engage in disruptive, discourteous, belligerent, impertinent, threatening, disparaging, or otherwise uncivil behavior. Again, not so sure. In fact, I don't believe at all that that would be constitutional. It's too vague and too broad. Just a little tip from Justice Douglas, who says, be alert if your rights are not being upheld. It may seem small, it may seem that things are seemingly unchanged, but he says it's in that twilight we must be most aware, however slight, unless we become unwitting victims of the darkness. He's talking about oppression. 2 websites, because I've obviously just gone across the tip of the icebergs here on all these issues. So Reporters Committee for Freedom of the Press, great discussions and resources, same thing. And of course, I'm a little biased as the president of NEFAC, but you can see for yourself. It's a wonderful website with a lot of great resources. So I think that's it for me, Emily, but anybody wants to send me thoughts, comments, concerns, questions, ideas, I'm always willing to look at them. And when I can, I usually reply. So thanks, everybody. Thanks, Emily Sweeney, and thanks, NEFAC.
Yeah. Hey, Greg, thank you so much for taking the time to explain this very important subject. Greg, thank you again. And thanks, everybody.